If you're going through a divorce and either you or your spouse are the owner of a business, the owner of a corporation, a member of a partnership, or any kind of business entity, that business entity may be a marital asset subject to equitable division. It's important to evaluate the value of that business. That can be done in a number of different ways. First of all, you have to determine when was the business established? Was it established during the marriage? If it was established prior to the marriage, let's say your spouse's business, their spouse is probably going to claim, or his attorney is going to claim, oh, that is not marital property. He had that business before y'all got married. But if his or her efforts made that business grow and develop during the marriage, it then has a marital property aspect to it. So we need to look into that and determine what's going on. A lot of times in a business, both spouses are actively participated. One may be the leader and the other may be working in a lesser role, but if both are working in that business, they certainly have a claim for equitable division in that business. So how do you determine what that business is worth? And what is an equitable division? Well, one way is that your attorney can hire an expert that can do a business evaluation. Business evaluations are not cheap. These experts go through the books. They look at everything going on. They look at comparable businesses and what they're worth, and they look at the potential income and the potential value of the business in the future. Another way is to gather the information yourselves to try to establish what the business is worth. It's important to have access to books and records, to have access to all the financial documents, all of the business-related documents that show value. You need to look at what the assets of that business are. Maybe they own vehicles, maybe they own equipment, maybe they own buildings. All those things are factors that have to be looked at. It's important that you have an attorney that understands this and has a knowledge of business, and I believe has a knowledge of accounting and business records. At Daniels and Taylor, we have that skill in our attorneys. I have a degree in accounting as well as business administration. My son Russell has an accounting degree as well as a business administration degree. Many of the other attorneys in our office have worked in business themselves or have degrees in business. So we have the knowledge and the skills in order to develop this information to present it to the court or to use in negotiating with opposing counsel. It's important to have an attorney that knows how to look for the necessary information, where to look, how to look at bank statements, how to look at credit card statements and pick out what's really going on with that business. Is there cash being made that's not being reported? Are there hidden assets? All those things are important. You should not try to do this yourself unless you are highly sophisticated in trying to gather this information. Hire an attorney that knows what he's doing that can do this job for you. It's important to protect your business interests when you're going through a divorce. It's important to make sure that that business is continuing to thrive and create the income that it has. It's amazing to me how many times we end up with divorce cases and all of a sudden the spouse says, oh, everything's gone to hell in a handbasket with the business. Nobody's doing any business with us. We're losing money. Well, a lot of times that is false. It is the impression that they want to create so that the court evaluates that business as being less than what it is and to keep you from getting your fair and equitable share. It's important to know how the business has run in the past so that we can evaluate how it's being run now. If you're actively working in the business, it's important to continue to work if you and your spouse are both working in the business, if you can continue that, I encourage it. If you cannot, it may be necessary for us to ask for a temporary hearing with the court to decide who is going to run this business in order to protect its assets and its income potential. The courts can do that. They can either put one or the other of the parties in charge, or they can appoint a third party to run that business. During a divorce, if a business has debts, those debts are, in fact, debts of the marriage, especially if you want the business to continue. If you're not worried about the business continued and those debts do not have personal guarantees, then those debts can be extinguished through the process of bankruptcy. But you have to look at all the ins and outs and what's going to work for the parties in order to continue the lifestyles that you and your spouse need and your children need. But debts have to be taken care of, usually through the business, so that they are treated as business expenses. It's easy to gather those things if you're actually working in the business because you have access. But if you're not actively working in the business, then the attorney has to go through what's called the discovery process. We send opposing counsel a list of discovery questions called interrogatories in which they have to answer. We send them a notice to produce documents so that they have to produce the necessary documents for us to evaluate what's going on with the business. And once we get those interrogatory responses and the documents, we will look at those over. And if we still have questions, then we can schedule depositions. Depositions can be taken of your spouse or any key personnel working within the business. If you have personnel that are in the office and handle the books, we can bring them in and ask them questions. If you have personnel that are outside the office and working in the field, we can bring them in and ask them questions. All this stuff is discoverable, and that's our job as your attorney, to gather it so that we can then present the facts to the court or use those facts to negotiate a settlement. There are several things that I see that are common mistakes during a divorce for business owners. The number one mistake is they share what they're going through with others in the business or with customers. This just puts a chill on the business. It also opens the door up for the opposing party to start subpoenaing your employees and or your customers to find out what you told them. Don't do that. Another common mistake is people sometimes try to manipulate the business to show that it's not doing well, not doing as it has done in the past. Judges are not stupid. They're going to look at what the business has done in the last year, 2 years. They're going to look at what the economic circumstances are, etc. If there's suddenly a drop in business right as a divorce is being filed, a judge is going to sometimes, often, ignore that drop and evaluate the business based upon what the history has been. That is one of the jobs of an attorney involved in the case, to show that sometimes someone is falsely trying to portray what's going on with a business. Don't do that. Let's be honest. You're in court. You're swearing under oath. We're not going to in court and lie. Another thing that happens with business is sometimes people just quit working. They walk away from it. If you've got a business that's thriving, is making you money, unless you've just decided you don't want to be in that business anymore, don't walk away. Don't let it go into default on its transactions and its obligations to its customers. Business in a divorce is very complicated. It is important that you hire an attorney that knows what they're doing, how to evaluate a business, and how to gather the information and present it to the court. Daniels and Taylor is the law firm that has that. We have attorneys here who are trained both in education and experience to evaluate and present your business situation to the court properly.